Great. Yeah, so unless anyone has like any pressing little introductory question, we thought that we will give like just a very fast overview of the model law, and then we kind of like really want to hear mostly your feedback, or if you have like some question, we are happy to also try and reply or discuss some points, like keeping in mind that this is a very preliminary draft, and we released it in order to create discussions within the community, and ideally we can revise it following the comments of everyone and release a new version. So just in a very, very short nutshell, so this is a project that started actually 2 years ago, before the pandemics. We had the very kind support of Gnosis and the GECO grant that has funded this research. And after 2 years, we finally managed to release something that we feel slightly comfortable about. But the original idea is really to create something to help governments actually identify ways in which they could craft laws in order to recognize legal personality and some legal capacity to DAOs. And that came from the initial observation that in many DAOs today lack legal personality and legal capacity unless they do actually register, and so they cannot really create legally enforceable contract. They cannot officially own property. They cannot benefit from limited liability. They cannot sue, etc. And then the problem that in many jurisdictions DAOs will be recognized either as general partnership or an other type of non-incorporated association, and therefore every participant could potentially be jointly liable for the DAO's action. And so the idea here is to create a legal framework in which DAOs could actually benefit from specific rights and associated obligation without actually requiring them to register, as long as they do satisfy specific legal provisions via technological means, right? And so the whole exercise that we want is to see to which extent we can actually identify the policy goals, the regulatory objectives that are underpinning traditional corporate law rules, and whether they can actually be addressed via technological guarantees that can be regarded as being potentially functionally equivalent to those corporate law rules, right? And so through the model law, we distinguish between this notion of functional equivalence and regulatory equivalence as two ways to bring the DAOs within the existing legal framework without requiring them to go into the traditional registration. And so the distinction that we have identified, and those two tools can be used and are being used within the model law, is functional equivalence on the one hand, which is looking at what is the function of a particular artifact. So for instance, like a paper document, and seeing whether that same function can also be fulfilled via a different type of artifact. So in the case of the UNICEF, the functional equivalence between paper document and electronic document for the purpose of fulfilling the obligation of contract law. And so here the same question is there any type of functional equivalence between the requirement and the formalities required within corporate law and the technological guarantees provided by the DAO? And then there is a further concept of regulatory equivalence, which is a little bit more far-pushing, which is not just looking at functional equivalence between the artifacts, so between like paper-based registry and blockchain-based registries, but actually looking at what is the purpose and what is the objective of a particular provision, and seeing whether the exact same objective can be fulfilled or can be achieved even though it's using a completely different way to do it via a particular technological mean. And through the DAO model law, we argue that given the technological guarantees that blockchain technology provides, some DAOs, if they do fulfill specific design criteria, could be considered to be either functional or regulatory equivalent to existing regulatory requirements in traditional corporate law rules, and therefore could be recognized as having legal personality and legal capacity and potential some type of limited liability. And the idea is really like, of course, you cannot force a DAO to be and to be designed in any way, but because of the desire that the DAO might have to fulfill those requirements in order to benefit from those legal benefits, then the legislator is creating an incentive for creating compliant DAOs. And so it's kind of like a give and give on both sides. So DAOs will comply with specific rules because they know that by compliance, they will benefit from perhaps legal personality, legal capacity, and the extent of limited liability that can be given. So that's kind of like the general gist of it. We can go through like the various chapters just like very shortly to illustrate the various provision. Yeah, Constance, do you want to do the first round?
Yeah, I'm happy to. So yeah, this is we had to really try to thread the needle and solve this intrinsic problem of how do we provide some sort of legal wrapper, limited liability, legal personality, some identity, legal identity to these amorphous decentralized creatures without requiring this formal registration or identification of all members and participants, which would completely frustrate the architecture and purpose of these decentralized entities. So, so using these kind of legal tools at our hand, we started doing a very onerous but necessary job of figuring out how do we achieve these public policy goals while maintaining the nature of DAOs. So how we distilled this was into 11 formation requirements. So this was a little bit of the trade-offs that Primavera is referring to. So, you know, if DAOs fulfill these requirements, which we try to keep as lean as possible, as opt-in as possible, those specific actions, these requirements would provide kind of the accountability or the notice and consent or all of these other public policy goals that exist in traditional corporate forms. So if you look at what we've done, one, and you know, I can give you a few examples of how we found this equivalence, and very keen to hear if you guys have other ideas of how this could work, or whether, you know, one mechanism we came up with might frustrate some DAOs. One was that the DAO must be deployed on a permissionless blockchain. So the reason for that is it's the transnational permissionless nature of participation that makes that justifies all of these changes in the law. So a DAO that's on a permissioned blockchain is, you know, you can easily identify who the gatekeepers are, who are the decision makers, who's participating. So permissioned blockchains were excluded from this model law. So the first requirement is permissionless blockchain. The second is providing a public address, and this is and also that the code has to be, you know, deployed in open source and audited and on you know, put on a user interface that's comprehensible to a lay person. So all of these kinds of formation requirements are kind of going to how can we keep DAOs accountable? How can we make sure that the participants have common knowledge, that the decisions that are made in these fluid organizations are legitimate? So we achieve this by providing notice and consent and access, by having bylaws that are comprehensible, the user interface, the open source nature of the code, the public the public blockchain, and to the point of ensuring that the model law only covers decentralized organizations. We put in a few provisions, formal requirements that ensure that the DAO continues to be decentralized, technically decentralized, even if operationally it is not. And we also put in a provision in which the DAO must be able to be contacted. So, all of these are ways that we try to get around requiring a formal registration requirement and identification of all the members, goals of ensuring, okay, people know who they're transacting with, that there's some way of contacting the contracting entity, and et cetera, et cetera. If you go into the commentary, we go step by step through some of these choices that we made, and happy to discuss this further and take any questions. But the way that we've designed this framework is, if a DAO takes the steps to follow these 11 formation requirements, which we try to keep as lean as possible, and maintain the decentralized nature of the organization, then the framework enables the grant of limited liability for the DAOs that have taken these steps.
Great. And then comes chapter 3. Silke, you want to speak to it?
Yeah. Hi, guys. I'm just going to give a quick. Can you hear me?
Yeah.
Can you hear me?
Yes.
Overview over the issue of mainly dealing with limited liability. So for DAOs in the space, especially for the illegal one, this is the biggest issue, because this is the biggest benefit you get with incorporating a company. You get the corporate veil, and the members are then not the whale. The members are then protected from liability. What we did is, so if you fulfill, as Constance just said, if you fulfill those 11 requirements, you also get limited liability. And I think this is probably one of the main provisions in the whole model law. And it's particularly special because it is for unregistered unregistered DAOs. So what Article 5 makes clear is that members will only be responsible for providing any on-chain contributions if there is something like that in that specific DAO. So that would be set out probably in some bylaws or, in the code. And if the DAO then exhausts those assets, the members will normally not be liable for any access liability. That's what is the case with any other. You have an LLC or a company limited by shares in various jurisdictions. You then, you're only liable up to your capital contribution, and that's what we reflected here. In addition to that, members will not be held liable for any of the obligations incurred by the DAO, and we put that in there specifically. This could have been summarized in one, but we felt it was very important to make clear that this also includes labor and tax obligations of the DAO itself, if there is something like that. However, because we had to make some compromises on having it like an LLC, where the company is registered in a specific jurisdiction, and in that way, courts have much more access to that specific company and the officers than in the case of a DAO. What we felt was that if that this limited liability may be somewhat maybe should be able to be pierced to ensure that DAOs still comply with, for example, enforceable judgments or orders entered against it. The issue you have as an unregistered DAO is that, well, how the courts or regulators generally going to ask, how are you going to enforce this against the DAO? And here we felt it was adequate to really a point of discussion. We had a very long discussion on this, that members who voted against compliance with a judgment or an order would be liable for any monetary payments in the judgment ordered against it. This basically wards off against them not complying with judgment, and we believe this should satisfy the regulator. Also, we thought that it would be important to state that the limited liability shouldn't affect the liability of members in tort or wrongful acts, but that they would only be liable for their own acts and torts and not those of other members. And this is really important in this respect, because if you are in a DAO, you want to make sure that you're not responsible for the actions of other members within that DAO. And guys, please chip in if I missed something here, which you consider important. It was definitely one of the more controversial provisions we made, especially sub-article 3.
I can just make a comment or a question, because in those cases, usually a judge, if there is an issue, it comes to a judge, and the judge will try to find, if there is a damage, he will try to find someone who's responsible and someone who can try to pay. So let's say that he cannot get hold of people who voted against, but he can get hold of he can get hold of the people that you try to exclude. Actually, I think the jurisprudence will actually, in front of those cases with such a rule, it will actually still try to fulfill this most important goal by the judge, which is to try to find an actual person who is capable of paying for the liability, for the damage.
Yeah,
so I think it would kind of be destroyed by the jurisprudence. This is my point.
Yeah, the reason why we added this was because of I agree that jurisprudence in many states, they would go after the lowest hanging fruits, the person that can actually pay for it. So we believe that if a state adopts the model law, that then also the courts would honor this agreement, because it becomes basically it's a model law. If they adopt it, then this should be the law as they the court should comply with it. I think there might be still a difference between civil law and common law jurisdiction on how far then the judgments could divert, but I'm actually not too sure. So the reason why we have specified it because it is so different in practice right now. But yeah, I think this is a very valid concern.
Definitely. And just to jump in, this has haunted our space, I think since its inception, that, courts will often go to the person who's most easily found or the lowest hanging fruit. So how to provide a legal framework that encompasses the fluidity and pseudonymity of these projects, but still allows for this liability when necessary and shielding when necessary has been has been the key challenge. So, one thing that we struggled with was, we're extending this limited liability if DAOs do X, Y, Z, but what about bad actors? How do we keep out bad actors? How do we put in sound provisions for when that liability deserves to be lost? So that's, just commentary on kind of our process. The other thing I just wanted to add is we are hoping that this is just the beginning. These are our initial thoughts. And one of our intentions is to leave open the room for DAOs to actually develop some more novel forms of addressing accountability, debts to creditors, that sort of thing, so that courts are less likely to impose anachronistic frameworks that don't actually track liability in these kinds of organizations and projects and actions. So one thing that we struggled with and ultimately decided not to include in the model law, for example, was a minimum capitalization requirement or some sort of deposit for debts. So things like, insurance mechanisms or that sort of thing. But one could conceive of a future model law or future developments in the space where DAOs have created substantive frameworks for insurance or liability that might fill in this gap. But this is what we've started for now.
Yeah.
If I may jump in, just very quick question. I don't see a specific class of developers highlighted in your proposal. So it's just stakeholders and members, but I mean, de facto, people who want to be shielded and people who are mostly responsible are developers. So why did you decide to omit them?
They should be covered in the definition. Should we have a quick look at it? Let me just try to find that.
Shielding developers, I know, was top of mind for this, because they're
exactly.
the ones who are most easily found and often least attenuated from some decisions, at least.
It's also touched upon in the commentary of the no implicit fiduciary status article that we will come to next.
It's also, I mean, it's in the definitions quite clearly. I think we'll have to, I'm trying to find it. But basically, I mean, this is the main class of people we're trying to protect. So
developer is in 8, 3.8.
Definition 3.8?
Article 3,
Yeah.
8. Page 17.
Sorry, my computer's running a bit slow. But yeah, so maybe you can just go over this while I try to.
I mean, we have a specific thing. I think it's in a later chapter on. We have in the fiduciary status. We have specific provision for developers. In this case, when we're talking about limited liability, we're actually talking about the members, which do not involve the developers, because the developers are not necessarily the members of the DAOs. So it's two different problems, right? One is like, how do we make sure that the general partnership of the DAO is not holding all the members, all the possible participants. Just because I hold one token, I might be held jointly liable to, even if I never engage with the DAO, as opposed to the developer, which is a different type of responsibility, which is like fiduciary duties. And this is tackled later on in Article 15.
Yeah, that's correct.
Okay, thank you. That explains it.
So I think we get to that later, but it basically states that you must not be imputed to have fiduciary duties towards each other and third parties just because they hold out each other's as if they solely because they are developers. I mean, here it says on account of their roles, but yeah.
I have a question, and also want to say, firstly, this is really impressive and really appreciate your guys' contribution to the space and going through all this. Is it possible for the DAO to have no human control? I saw that a member can be a DAO itself. And if that is the case, how much confidence do we have in smart contracts to be sophisticated enough to operate a DAO without human intervention? And I'm borrowing this point from Daza Greenwood, who brought it up in his testimony to the Wyoming legislature.
So actually in our definition, in terms of formation, which is basically defining what these model laws apply to, there needs to be one member. As in, like, we consider that DAOs are specific types of smart contract which involve human governance. This model law does not apply to a pure algorithmic smart contract. I mean, this is the definition that we gave to the DAO, and that's what scope the purpose of this model law. What's defined the scope of this model law, which is we are not covering any smart contract. We are not claiming that we should provide legal personality, legal capacity to a smart contract that is just algorithmically dealing with things. But whenever you do have human governance involved, then it becomes what we define, like it fits within the scope of what we define to be a DAO for the purpose of this model law. But you need to have at least one member.
Okay, so the member can be
the member
one
can
member
be a
could
DAO,
be-
of course, but
yeah.
eventually, if this member needs to be a DAO, so it needs to be itself governed by humans and so forth. So it's like turtles all the way down.
Okay, gotcha. Thank you. My other question was, I would love to hear more about how you guys are thinking about counterparty risk. Like, for example, if the DAO wants to hire, let's say, a smart contract audit company, how does that smart contract audit company get comfortable doing business with the DAO? And I think some of this comes back to the limited liability, but I was also interested in the points kind of around the, counterparty beware and the discussion of, dispute resolution mechanisms. And I'm curious how much we're trying to have DAOs be able to do business with other. Are we trying to allow DAOs kind of enter the mainstream world of doing business with traditional corporations, or do we kind of see the typical counterparty being people that are comfortable taking the risk of interacting with this new kind of legal personality?
One of the most important features for us to allow DAOs to have limited liability was the transparency. So the transparency requirement, also in the formation requirements, is super important. So we feel that, yeah, we would like DAOs to have relationship to legacy system companies, and that should be made possible through covered emptor, basically through the other counterparty knowing with what entity they are dealing. And this is also one of the reasons why we have defined DAOs to be on a permissionless blockchain and not on a permission blockchain, and that the smart contract should be accessible and reviewable to the other party. So I think this is the reason we used to explain why this should be possible. And I mean, if we saw this in relation to Tracer DAO, where they agreed, they basically signed, and of course they questioned on whether the signature is actually valid, an agreement with an audit company. We hope that more and more of these agreements are going to be entered in, and that actually DAOs become a normal counterparty to deal with. In terms of like in the real world, a lot of LLCs have no capital requirements. We think that with the technical equivalence which we build into this law, we actually allow parties to have a similar level of risk, so long as there is actually a method of dispute resolution, which we also made a requirement in this model law.
Okay, thank you.
Kind of have a related question, and I just want to also say I think what you guys are doing is awesome. I'm really excited about the project. The related question is around default and bankruptcy. So how confident are we that any counterparty that's engaging with the with the DAO, on terms where the DAO is holding tokenized assets on its balance sheet, that we can contract in such a way that there's no recourse against against the value that the DAO owns beyond what's coded into the smart contract, given the kind of statutory frameworks around around bankruptcy.
We didn't make any special provisions on bankruptcy because it's so jurisdiction specific. But we also felt that, and guys, please correct me if I get that wrong. We also felt that no specific provisions would be necessary on this point, and we are happy to actually add some or have a discussion on that. It wasn't part of our framework. The issue is you should be able to apply. I mean, we should be able to apply the bankruptcy frameworks also on a DAO as much as for example, an LLC, due to the technical equivalency we see in the way the DAOs are structured and the LLCs. Of course, you could then, yeah, sorry.
No, sorry.
I should maybe add
wasn't saying
something
anything.
here. Yeah.
No, so I just wanted to add that. Sorry, I didn't mean to interrupt. I was
No,
just
please,
talking to
please.
myself.
You're the expert on this one.
No, so I was. This is something that we address a bit in the commentary to Article 2, where we talk about what it actually means to have separate legal personality, and like the distinct having entity shielding, and then having another provision about limited liability and owner shielding in this way. And our aspiration, in a sense, is to get the benefit of separate legal personality, and in that sense be able to compartmentalize the DAO's pool of assets from those of personal creditors of, for instance, a DAO member, but that it should also work the other way around. Now, the question is that when integrating this sort of a provision into not just company law, but the bankruptcy law of a jurisdiction, there might be, as Silke just mentioned, like there might be public policy grounds that are particular to a jurisdiction about why they would want to, let's say, claim the assets of the entity, find a reason to pierce the veil during, in the proximity of bankruptcy, for instance. And obviously, that's harder to give like a sort of global summary of, or try to reflect the global position of this in this sort of a law. I think one of the things we try to do is something akin to what a lot of legal systems do, where they separate corporate law from bankruptcy law and deal with it in separate pieces of legislation. We suspect that the bankruptcy law of a particular jurisdiction might have also certain procedural problems in trying to access certain types of assets. And this was something that I remembered that did come up during the early discussions on some of these articles. And I think that is one of the issues that with the publication of this document, we hope it'll be raised. So, for instance, in what context and what circumstances should an asset be transferred? What requirements do insolvency professionals, whether they're appointed by the state or they're private ones, what like requirements should they have in terms of creating, let's say, their own wallets and trying to interact with the DAO on chain? Obviously, none of that really exists in that exact form, even though there have been efforts in doing like there have been some cases where bankruptcy courts have dealt with crypto assets, but there's no like sort of systematic way that a lot of jurisdictions are dealing with this for us to comment upon. So I think it's a very important point, but it's hard to know how to, at this stage, deal with it both like doctrinally as a matter of law, as well as a matter of procedure, in a way that would be able to, I guess, satisfy everyone here.
Got it. Thank you.
But we'd love your ideas if you do have some for this problem.
If there's no other question, maybe we can move on to chapter 4. Marsha, do you want to go?
Yeah, let me just go back there. So chapter 4 deals with the internal organization and disclosure requirements of this model law. And there's, I think, two main themes that are very important. The first is about giving the DAO as much flexibility as possible in terms of setting up its internal organization and meetings and other sorts of internal governance and dispute resolution procedures, while at the same time meeting certain public policy grounds with respect to, for instance, giving adequate notice to those involved in the governance. So we try to, apply the functional equivalence approach here, as I will discuss shortly. The second, I think, major theme here is the last article of this chapter, which is about fiduciary liability. And what we try to posit and then defend is that there shouldn't be implicit fiduciary status ascribed to any particular role holder, purely because of the fact that they hold a particular role or title. And then in the commentary, we sort of try to go and explain why there is a risk that certain role holders could be held or considered to be fiduciaries, for instance. But this is perhaps like a misunderstanding or a misguided approach to dealing with this issue. And that as part of developing this model law and engaging with regulatory authorities with this, we need to think of ways of trying to overcome this, while also acknowledging that there can be situations in which a DAO might wish to have a fiduciary, and then consider the implications of that as well. So those are the two sort of major themes. Looking briefly at each article in turn, the first one is sort of very, very brief. It talks about the fact that the bylaws of the DAO should set out an internal organization and procedure, and it's not prescriptive in any way with respect to this. And this is, I think, quite uncontroversial in the sense that there are a lot of corporate entities whether in the US or in the United Kingdom, but also across continental Europe, in many advanced jurisdictions that allow a great deal of flexibility on how internal organization is set up. Similarly, while a lot of corporate laws that we looked at, especially model corporate laws that we've looked at, they have provisions about meetings. And of course, there can be situations where a DAO might need to have a meeting, just whether that's on a regular basis or annually. That's quite a typical requirement. However, we also acknowledge that DAOs, because of the particular nature of how they operate, may not wish to have a synchronous meeting, but have, for instance, asynchronous engagements with each other, partly because of its globally distributed nature, its pseudonymous nature, for various reasons. It might be better to make the requirement of having a meeting an optional one. And again, the bylaws would explain why that is. Of course, again, because of the nature of how DAOs operate, this shouldn't be necessarily physical and in person. And I guess that's especially uncontroversial now, but what's, I think, in a way in our favor with respect to this is that during the pandemic, certain legislatures have started passing either temporary or permanent legislation that allows, for instance, shareholder meetings of companies to be held online and votes to be recorded online and so on, which didn't exist everywhere before. And so this is for us also like quite obviously an important requirement. There's, I already mentioned the point about the requirement for there to be a notice mechanism that is transparent and is given on time. We give a suggestion that it should be communicated through a GUI, and we have requirements about how the bylaws should set out like a notice period that is very clear, and that anyone joining as a member of the DAO will know this at the moment that they join. And similarly, because we acknowledge that there will be different levels of engagement by members of a DAO, depending on their size, depending on the nature of their activities, that being prescriptive about a quorum requirement or about how many like what a majority requirement is, whether it's just a general one or a supermajority one, etc., would be difficult and might be overreaching. We decided to leave that open to individual DAOs. Now, starting to turn to some of the, I think, a bit more heavily discussed provisions in this chapter, we looked at Article 13, which is about whether we need to have administrators in a DAO or not. And obviously, I think one of the aspirations with operating a DAO is to be able to collectively govern without the need for administrators. But at the same time, there are certain instances based on the existence of DAOs already where administrators are very useful and are needed. And so we felt that it should be something that is, again, made like a default option rather than a mandatory one. So the bylaws specify whether someone is mandated to be an administrator, and that if there isn't a provision made for an administrator or administrators in a DAO, the DAO members as a class will collectively govern. And again, the whole procedure for how these administrators will be appointed will be specified in the model law. And I can imagine that there will be some best practices that emerge about how this can be done in a way that is seen as legitimate to DAO members. And I think over time, we will know more about what that could look like. Article 14 goes into the issue of legal representation. And while legal representatives are can sometimes be conflated with, let's say, the role of an administrator or a role of a fiduciary, here we try to narrowly focus on legal representatives just being agents who are appointed for a very specific purpose by the DAO to, for instance, let's say, rent a venue where a physical meeting might happen, or to go to a particular office on behalf of the DAO. And here the idea was that there should be a transparent and verifiable mechanism for the appointment of this representative, as well as a very clear and carefully defined articulation of what their responsibilities are. And we, in the last couple of sections in 3 and 4 about 14.3, 14.4, we explain that there are no requirements as to where the legal representative is residing. So again, this is distinct from certain requirements about, let's say, forming a trust in Delaware or in a particular state, and then you need to have a registered agent there. We want to try to give more flexibility that the legal representative may not necessarily be based in one particular jurisdiction, and then thereby try to avoid some of the potential implications that this legal representative is basically someone who we can use to try to understand where the DAO is, quote unquote, territorially located, and use that as a basis to bring them within a particular jurisdiction. And similarly, to protect the legal representative and to encourage people to hold out as legal representatives, we also try to protect them from personal liability. So it could be the case that, and as we mentioned elsewhere in the model law, that there are situations where DAO members can be held liable for fraud, or collectively and individually, but purely on the basis of an act that is done done by the DAO, that should not lead to personal liability for the legal representative. They could be held collectively and individually liable because of something else that they did, wearing a hat as a DAO member or as an administrator or something else. But here, because of their narrowly defined role as an agent, they shouldn't be held responsible for things that the DAO has done, basically. And finally, and I think the most controversial, in a way, provision, and one we discussed quite a bit, is about what to do with the fiduciary implications of of operating a DAO. And this deals with not narrowly defined roles as an agent, but rather discretionary decisions. And as as has been discussed in this space quite a lot, there is a risk that if certain persons or certain stakeholders are deemed to have discretionary power, they are attributed the role of being a fiduciary, and as a consequence of this, if they fail to meet certain fiduciary duties such as good faith, care, loyalty, and so on, which exist in some form in many jurisdictions, it leaves open the possibility that unwittingly they become fiduciaries and fiduciarily liable for certain actions that they take on behalf of the DAO. And what our argument is, and we elaborate upon this in the commentary, is that there are certain misunderstandings about what the powers and the extent of the discretionary abilities of each of these stakeholders are. And so, for instance, we talk about how blockchain developers, like open source developers, don't have control over the ways in which their code, once written, is used or modified. And they cannot always impose a particular code change onto the users of the software once released. And similarly, we talk about this with respect to other stakeholders like cryptocurrency exchange operators, about, let's say, the legal representative and so on, and consider to what extent do they fit into the mold of a conventional fiduciary. And because of this, we say that it shouldn't be something that is attributed to them, fiduciary duty shouldn't be attributed to them by default, unless they explicitly hold themselves out to be a fiduciary, or they deliberately are chosen to be a fiduciary for a particular purpose. So that's basically, I think, all of the points for this chapter. If anyone has any questions.
Hey, Murshad. First off, congrats on this model law. I very much enjoyed reading it and do have a lot of comments. But I mean, it's been amazing to see the work in progress actually having these types of results. So my question would be to the third point of the Article 14. Is there a need for the reciprocity of some sort? So saying that, sure, there is no requirement as to the residency and seat of the legal representative, but maybe just adding that such a residence of the representative in no way actually affects the DAO status as well. And then for the fourth point, my understanding is correct, right? That as long as that person actually acts within the limitations that they are provided, they're not going to be personally responsible. But if they, for example, surpass and do something way beyond their responsibility, then they might actually become personally responsible for those actions. That's also a question.
Yeah, thank you. And I'll just quickly speak for myself here before, and if anyone else wants to jump in. But my understanding is that with 14.3, there should be, and the understanding that you mentioned, in the sense that there, it's sort of right now implicit that it wouldn't affect the DAO status based on where the legal representative themselves is located. And that's the reason why we included that particular part into this this article. And so yeah, I agree. And then with the last one, I think it is true that if they act beyond their capacity of a legal representative, there will be, I think, two implications. Obviously, the first would be that those acts wouldn't be valid in terms of binding the DAO. And then I think there it's a question, and secondly, it would be a question of who would hold the legal representative accountable. I think there it wouldn't just be, let's say, a counterparty, but it's potentially also the DAO itself, because the DAO would want to take steps against the legal representative for acting beyond the remits of their terms of reference.
Makes a lot of sense. And then just to the point one, when it says a DAO may choose to have one or more legal representatives, would it make sense to actually make a demand that such an option is actually written in the bylaws? or is it just a general option that people have, or a DAO has, whether it's crafted in the bylaws and provided in the bylaws or not?
I mean, I'm curious what others think about this, but personally, I think the reason why we didn't make it prescriptive or make it a mandatory rule was because we imagined that there could be certain DAOs that, for instance, operate using symbolic tokens or are not necessarily like businesses in the traditional sense, which have a lot of, let's say, both on-chain and off-chain interactions. So it could be possible that it's something that doesn't immediately need, at the time of formation, a legal representative. We wanted it rather to be that, let's say, a DAO evolves at a certain stage from being almost like a project that is started by, let's say, like a small group, and initially just subsists on chain. Once maybe it starts evolving, and then at some stage it does need to appoint a legal representative. So rather than preempting this and saying that no, from the very beginning you need to have a legal representative, it's rather something that they're allowed to have at a later stage once it becomes necessary for them to start having a legal representative.
And to add to this, I think there was also the thing that the DAO can actually have a functional approach to its own representative. And so it's not like that you have one representative or like a series of representatives that are covering the whole function, but the DAO could say, for the purpose of, I don't know, renting a particular office space, I want to go through this representative. For the purpose of purchasing an asset, I want to use a different representative. For the purpose of, I don't know, dealing with like taxation or whatever. So basically, you can have different actors that are functionally responding to the need of representation for the DAO without necessarily having to have just one single representative that is covering all those aspects.
Thanks. That makes a lot of sense. Yep.
Okay, we have a few minutes left. Is there like any comments, as in like, I mean, we can go to chapter 5, but I think it will be more interesting perhaps to hear from you if you have like beyond questions, but if you also have like comments about how do you think it could be improved, what do you think maybe has been forgotten, or just any suggestion for revision.
I was just curious to get your thoughts on what the like what you think the prospects are like longer term of you know, of a jurisdiction implementing this. Like what's the kind of longer term like vision? How do you see it playing out?
Yeah, I mean, this is an important discussion that we had internally. The idea is really like at this point is creating discussion and awareness about what could be done, right? We don't really yet have an agenda about like how do we want to push this, but just the fact of actually putting it out there is also a way for engaging in conversations with regulators. And our core objective, I would say, is like actually creating this awareness about the possibilities of recognizing those new types of functional equivalence and regulatory equivalence within the technological guarantees. And instead of requiring, you know, some radical legal reform or creating things that are specific for DAOs, what we are hoping for is that we can show to regulators that actually maybe not so much needs to be changed if we do actually, if we manage to show that some components, some technological designs that some DAOs might adopt could actually be regarded either functionally or regulatory equivalent to existing corporate rules. And in this case, you actually don't need to change much. right? You just need to, as a regulator, to recognize that there is this equivalence, and then automatically then the DAOs that fits within the scope of this equivalence then could benefit from existing regulatory provisions. And then, of course, in a later stage, then try and see whether this can actually be more precisely adopted and refine the law in order to fine-tune it and to accommodate also the new properties and the new potentiality. But as a short term, I think it's really like, let's engage in discussion. Like, let's show that some easy regulatory fix are possible that will actually tackle a lot of the problems that we encounter. And most importantly, it's about showing that there is a way in which regulators can actually incentivize DAOs to fulfill specific criteria, despite the fact that, of course, other people that do not care about getting those legal benefits will still deploy DAOs that are completely outside of the scope and do not meet those requirements. But if the regulators are actually willing to provide some benefits, and of course, partial limited liability is one of those benefits, then you might, by giving that, you might actually encourage DAOs to listen and to comply. So that's kind of like the main initial objective. And then, of course, it has to be seen how things evolve and to which extent we can actually push for a more widespread adoption of those provisions.
Gotcha. Makes a lot of sense. Thanks.
Okay, maybe Greg, you want to just say a few words for the last chapter before we close?
Did we have more questions? Like, I agree that it's more interesting to hear from the crowd, but I'm happy to go through it. So basically, Chapter 5 addresses these things that are raised by DAOs that aren't really concerns faced by traditional corporate law. The overall goal is to provide certainty for the public, but also for DAO members and participants. So just to go through it very quickly, 16 looks at contentious forks. So what happens if the underlying blockchain has a contentious fork and there's some dispute about what's the new dominant chain? So we default to going with the majority chain, and we provide a kind of mechanism for determining what that is in the definitions. But we also give flexibility for DAOs to make different choices if they want to. That could be going with the minority chain or splitting into multiple entities or redistributing the assets in some way. And we require public signaling if that's going to be the case. 17 looks at DAO restructurings, so things like updates or upgrades. Basically, this says that the legal personality will continue as long as the DAO continues to meet the registration requirements of the DAO model law and advises the public of any changes that affect the public address. And lastly, we look in 18 at DAO failure events. Failure event being defined as a technical bug or exploit which renders the DAO unoperational or fundamentally changes the way it operates. So in this case, we maintain legal personality in order to protect the members, unless there is some kind of malfeasance or gross negligence on the part of the person or persons doing the upgrades, in which case there might be personal liability against them.
Thanks, Greg. Just to, before we close this, I just want to mention the last two provisions are just kind of catch-alls. One is just specifying that tax should be individual, much like LLCs operate in the US, because it's just not feasible to identify every jurisdiction tax obligation of every participant in a DAO. And then the other is just a gap-filling provision in which ordinary business law might step in where there are gaps, but it should not frustrate the spirit of the law. And, this is really just kind of a first articulation. I think it's the first articulation of its kind that translates what laws, what sound regulations might look like that fit the technological characteristics and opportunities and regulatory opportunities of DAOs. So on one hand, it provides regulators with a spectrum of behaviors and a path forward that they can adopt to allow these businesses to operate in their jurisdictions while meeting their public policy obligations. And then on the other hand, it provides signaling to the DAOs to as a path forward in terms of what kinds of constraints or formalities could they adopt now as a self-organizing principle, self-governing principle, so as to assuage regulators that these kinds of projects and organizations can be operated safely. So it's really just that first translation, which we think was super important, and would love any and all feedback on where we might have gotten it wrong, where we could improve, and how we can make this work a little bit better.
Great. Maybe Alexi, you want to ask your questions or your comments?
Yeah. Yeah. Thank you, Primera. Just to go back, sorry, I missed the opportunity before, so it's just to come back to Article 1 and also the definitions and Article 4. Sorry. So first, just a comment, or it's a question, maybe that's not really a big deal, but I see that in nature, you kind of like set out the different objectives: commercial, mutualistic, social, environmental, and political purpose. Why choose like a specific, even though it's very broad, why choose a specific set while it could be actually anything that people want, rather than limited to these kind of purpose? So, like, would a like more open Article 1 be simple, more simple, or there's a specific need to pinpoint to those? I don't know if anyone has an answer on this.
Sorry, no, sorry.
Go ahead.
Who was? I like how we start speaking at the same time after a pause. No, so I remember we were discussing about this particular provision some time ago, and I think for one, it was I think based on the fact that we would be looking at different sorts of model corporate acts, and quite a few of them seem to specify that what is the purpose of the creation of this new entity form? Is it for mutualistic ends? Is it for any sort of for-profit business activity? Is it? And I appreciate that this isn't universally the case, and there are some places where it basically just says any sort of lawful activity is permitted. But I think we partly looked at that and then tried to think of, okay, how can we make it expansive enough to try to incorporate a lot of different sorts of activities? And secondly, I think it was also trying to reflect a bit about what we were seeing as happening already in this space, and try to encompass those sorts of activities as well. So both that are more sort of financial, but also those that are basically interested in creating collaborative communities, and so on, and potentially also I guess philanthropic activities as well.
Yes, we looked at, for inspiration for this model law, we looked at the whole spectrum of organizational laws and different purposes under which these organizations are formed. And a lot of the time we saw, kind of for-profit entities with a specific provision in preamble. We saw nonprofit entities with of course, a different kind of preamble. So I think by spelling it out, we wanted to be very clear that we are not distinguishing between charitable and non-charitable and for-profit organizations in this law.
Okay, yeah. So like, okay, that would be a good reason, I think. Okay, thank you. I have the other point I'm a bit more concerned, is the delimitation you put as the DAO should be built in on the blockchain. So first, let me tell you, I really appreciated the definition of permissionless blockchain. I think that this one is great. As a general thing, people were saying the whole document is great. I already told them directly to Primavera and to Florence. But yeah, so permission blockchain is great. The DAO itself, I think we have a limitation there, because I can see some developments. For example, if you take developments such as RGB, I don't know if some people are familiar to this. So it's a layer. So you have Ethereum, Bitcoin itself, which is a simple settlement layer, but secure settlement layer. Then you have Lightning, which is a second layer, and then on top are built things like RGB. And RGB has some specifics. It's still some cryptography and some algorithm that are and some scripts which are put together to organize things between participants. But they you could imagine in a future basically that the state of the organization is not connected to a blockchain. It does have assets. It can control assets on a blockchain, but the state of all the contract is not set in a blockchain. It's actually shared between the participants. I know it's a bit it's something we're not used to it right now, but what I mean is that by saying this is that the current form of how we perceive a DAO might not be the form that it will look like, or some of the element of a DAO might not look like we think about how we think it about now. So I feel this definition is restrictive in the sense that when we will see evolution of way we interact with blockchains, we might not be able to catch those ones.
Yeah,
I don't know if I was clear.
That's a very good comment. We realized it a little bit at the last moment, and we tried to address it with footnote number 12, which is a footnote to the definition number 7 of DAO. And we kind of started struggling a bit because it's actually really hard because things are still in the making. So we literally just made it as simple as possible by saying this definition should also apply to any layer 2 solution as a footnote to public permissionless blockchain. I don't think this footnote is good enough, that's for sure. It's really hard. Like, I mean, if you have any suggestion, please go ahead, because it's really hard to define all these possible ways in which a DAO could be implemented, and that will still be recognized as a public blockchain DAO as opposed to a private DAO. So we kind of cheat, I think, by just putting this footnote to say, well, don't worry, layer 2 is also taken care of. I don't know how to tackle it, actually. I don't know what would be the best way, in a way that wouldn't, by defining it too strictly, again, be limited, because new things might come up in the future. So I don't know, what's your take on that?
Yeah, it's really hard. Yeah, indeed. I think one of the things is this is what you're trying to achieve with the definition of the public on the public blockchain also, is the kind of like autonomy, like that your actions are not dependent on the action of someone who has a kind of control. But this basically this will be soon also with a mixture of blockchain and other types of technology, be able to it will be possible without being fully visible. So for example, the address would be a problem if my organization is a set of RGB contracts, smart contracts, and that I share those contracts within the group of people where I am within the member of the DAO. Well, there might not be a public place for that is as obvious to connect to. But anyway, I would say that the autonomy would be the criteria or the self-sustainability of the organization.
And one of the criteria that we would need to consider, and that's why also an address was specified, is the transparency of it all, because we use it as one of the regulatory and functional equivalent, actually. So, you know, we use the argument, well, we don't need this registration because everything is transparent, and that actually is a technical equivalent to what you're trying to achieve with your legacy system laws. So I think that's also a very hard topic, that if, you know, you can't really see, the public can no longer access that, then, you know, we lose one of the arguments that we use to say that this is actually as good as registering.
Okay, so that would be one of the compromise. If a DAO wants to interact with the traditional law system and have some benefits, then there is a kind of obligation of a certain level of transparency that it has to meet.
Exactly.
Yeah, I mean,
really
that's the
love
idea of like the compromise, right? It's like if you want to benefit from legal recognition or protection, you also need to give a little bit as well.
But we'd love to have some input on the layer 2 solution integration. So
Yeah,
that was really difficult. I mean, we looked at it quite late, so.
It's hard because it's full in development right now. So all the options that we see, I think people don't understand much the all the options that you have. It's hard.
and I think generally, like, it's hard to define even like DAOs, you know, like, which are not or smart contract. Like, it's really hard to not make it blockchain specific. So it's like we're trying to use like as little specificity in the terminology, but you know, at some point it becomes too broad or just doesn't mean anything anymore. But that's definitely something that we need to think about for the revision. And if you want to help out with that, that will be super cool. Cool. Is any other comments or questions? Great. Well, so I mean, we're gonna put the model law is on the website of COLA. We might put it on GitLab, so people can comment. And yeah, we're looking forward to the general feedback. So don't feel free to just email or reach out if you have like other idea, or if you want to be involved in the process of revision and drafting the follow-up. Yeah, we will be very happy. And yeah, I think we can make a little congratulations and applause to all the koalas and non-koalas that have helped out and that have kept going in spite of the pandemic and that have engaged into thousands of hours of discussion on Zoom. And once again, thanks a lot for Gnosis and the Geeko grant. That was extremely helpful as well. So yeah, maybe we can make a little round of applause for everyone that contributed.
Here, here.
Thank you.
Yeah.
Cool. Well, so this chapter is over. The new chapter on legitimacy is starting. It's gonna be just as fun. So everyone is welcome to start thinking about what is the question and the definition of legitimacy in blockchain communities.
Great.
Any last words from our little koalas?
I'm really proud of what we did, so I hope that we'll get some engagement and that we can improve it further.
Yeah, I think it's an excellent first draft. Cool. Well, thank you, everyone. It was a pleasure. And I hope to see you soon.
Congrats.
Thank you for your work and really good job.
Bye-bye.
Thank you. Bye.
Bye.
Bye-bye.